Welcome to the September 2025 edition of the Essential GovCon Brief, episode 14, brought to you by Gordon Reese. I am Patrick Burns.
And I'm Laegan Meyers. Each month, we provide a focused review of legal and regulatory developments in government contracting that matter to your business.
Laegan, good to have you back on the
Thanks for having
show.
me.
This month's discussion covers three significant updates: the FAR Council's inflation-based adjustment of acquisition thresholds, the clarification regarding pre-award registration in SAM.gov, and a recent Court of Federal Claims decision addressing both proposal compliance and SDVOSB eligibility.
Let's begin with the FAR inflation adjustment. On August 27th, the FAR Council issued a final ruling adjusting numerous acquisition-related thresholds for inflation, as required by statute every 5 years. And so these changes are effective October 1st, 2025.
So key increases to the acquisition thresholds include micro purchase threshold increases from $10,000 to $15,000. The simplified acquisition threshold increases from $250,000 to $350,000. Threshold for requiring certified cost or pricing data increases from contracts valued from $2 million out to $2.5 million. And those are for contracts issued after July 1st, 2018. The requirement to submit a subcontracting plan now applies to contracts exceeding $1,000, up from the previous number of $750,000. Further updates, you can review the Gordon Reese Government Contracts Practice Group webpage, and we have all of the acquisition thresholds listed there.
And so, in addition, thresholds governing justification and approval requirements have been raised. So, for example, the dollar levels that trigger higher level approval for sole source procurements now reflect the inflation-based increases.
The rule also makes adjustments to thresholds that apply during contingency operations. A contingency operation, for those of you who don't know, is a military operation designated by the Secretary of Defense in which U.S. Armed Forces are or may become involved in hostilities, or when the armed forces is engaged domestically during periods of national emergency. So in those situations, higher thresholds apply to give agencies greater flexibility.
And so finally, it's important to recognize what has not changed. So thresholds tied directly to other statutes, such as the Davis-Bacon Act, service contract labor standards, performance and payment bonds, and the trade agreements thresholds all remain the same.
All right, on to the next topic. On August 7th, FAR Council issued a final rule clarifying when an offeror must be registered in the System for Award Management, or SAM.gov.
So the rule confirms that contractors do not need to be registered at the time of proposal submission. Registration must be active by the time of award. And so this clarification resolves a longstanding ambiguity.
However, the rule also emphasizes that solicitations may require earlier registration. If a solicitation specifies that registration is due at the proposal submission, contractors must comply with that requirement.
So the rule further clarifies that registrations must be active, not pending. A contractor with a registration application in progress or with a lapsed record is not eligible for award.
And this clarification is significant because SAM registration is the government's mechanism for verifying representations and certifications, as many as you know, as well as checking exclusions and confirming eligibility for awards. There's a deficiency that exists and the registration is not updated, it could result in the loss of a contract. Contractors should ensure that their SAM registrations are renewed and active before award decisions are made.
Yeah, that's right. And so to lead into the third topic we've got today is the development in the Court of Federal Claims decision that was issued on August 1st in Veteran Elevated Solutions versus the United States. And so the case arose from the Department of Veterans Affairs procurement for elevator upgrades at its Richmond, Virginia hospital.
And the solicitation was an SDVOSB set-aside, service-disabled veteran-owned small business set-aside. The VA awarded the contract to Armstrong Elevator Company. Veteran Elevated Solutions, another SDVOSB, challenged the award on two primary grounds. First, that Armstrong's proposal was materially deficient because it failed to provide the required subcontractor information. And second, that Armstrong was not actually controlled by a service-disabled veteran and therefore was not eligible as an SDVOSB.
The court rejected the first argument, holding that the subcontractor information at issue was not a mandatory minimum requirement. Rather, the VA's treatment of Armstrong's omission as a weakness rather than a deficiency was consistent with solicitation and was not arbitrary or capricious.
But the court took a different view on the SDVOSB eligibility challenge. Veteran Elevated had argued before the SBA's Office of Hearings and Appeals, or OHA, that Armstrong's veteran owner was not exercising sufficient control at the time of the April 2024 bid. OHA rejected the protest, but relied heavily on Armstrong's certification file from 2021 and a 2023 disability letter.
And the court found that OHA's reasoning was inadequate. OHA did not meaningfully address the evidence presented by the protester, including allegations of the veteran owner's outside business interest and questions about his availability even to manage Armstrong's daily operations. Nor did OHA explain how the record demonstrated eligibility as of the April 2024 bid date, which is the correct standard under SBA regulations.
The court emphasized that OHA failed to connect the evidence in the record to its conclusion. Simply reciting that Armstrong was eligible without weighing or explaining the evidence was insufficient under the Administrative Procedures Act. The court remanded the case to OHA for a full reevaluation and stayed contract performance pending that outcome.
The lesson for contractors is clear in this case. Certification alone is not enough. So eligibility must exist as of the date of the offer, and OHA must base its determination on the current record and not outdated files. Contractors should be prepared to demonstrate ongoing compliance with SBA's ownership and control requirements.
So that's the episode. Thank you all for listening. We've reviewed the FAR Council raising the multiple acquisition thresholds, which are effective October 1st this year. The FAR mandate that expressly requires SAM.gov registration to be active at the time of award, though, as mentioned before, solicitations may impose earlier deadlines. And we also reviewed the Veteran Elevated Solutions case, which highlights the importance that ADA eligibility is demonstrable as of the bid date.
So these developments each have immediate implications. Importantly, contractors should ensure that their small business certifications can withstand scrutiny if protested.
So that concludes this month's Essential GovCon Brief. I'm Patrick Burns.
And I'm Laegan Meyers. We look forward to joining you again next month with further updates in the government contracts arena. Thanks for having us.